be hearing it's kind of a technical case, and I'm not going to try to explain it to you because I think it'll come out as you listen. I thought maybe I'd explain to those of you who are in the audience that justices on the real court are as obnoxious as you will see my students. That they are being rude, but that's how real justices are. And so they will be interrupting and talking back and forth, and that's just kind of how it works. So please don't think low of them for acting in that way. So same drill, make sure you've shut off your cell phones and all of that. And I am the clerk, and I'll get us started. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oh yes, oh yes, oh yes. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, so we'll begin today with case number 11-1351, Levin v. United States of America. Counselor, you begin when you're ready.
Mr. Chief Justice, does the court care for a brief recitation of facts in this case?
I don't think we need it.
I don't think so. Okay, I will start then. So we're here because the Ninth Circuit, on appeal from the Ninth Circuit Court of Appeals. In this case, the Ninth Circuit held that my client didn't have that my client's medical battery claim could not proceed under the terms of the Gonzalez Act. And we're here today because the Ninth Circuit has just not really understood the development of the waiver of sovereign immunity that's occurred over the last several decades. When the Federal Tort Claims Act was established back, I believe it was in the 60s, the purpose was to give plaintiffs that were injured a party from whom to recover, while also insulating government employees from personal liability. And consistent with that, the Congress has continued to grant federal employees additional personal immunity with subsequent acts, while also maintaining the basic framework that injured people who had a viable claim could collect from the United States government, who essentially steps into the shoes of the wrongdoer.
Now, Counselor, on the issue of immunity, this court has empirically required that a government's waiver of sovereign immunity must be immutable and quite clear, and the petitioner's reading of the Gonzalez Act has been called plausible at best. Are you requesting that we overturn precedent in regards to the sovereign being waived?
I don't necessarily think the court has to go that far. I think there's other case law, including the FAA case, that standard does require a clear waiver. However, it's a clear waiver based on just the natural interpretive tools that the court uses anytime it's
Counsel, what are those
considered
natural interpretive tools? What words or language would indicate that we unequivocally waive, Congress unequivocally waive sovereign immunity in any instance?
Well, again, we're looking for what's the clear reading, what's the clear way to interpret these statutes.
Counsel, I believe that everyone in this room is looking for the clearest way to interpret statutes. We're curious as to how and what methodology you're using to arrive at your interpretation.
Argument that we would submit to the court is that this statute, along with which is similar to the Veterans Affairs Act that was discussed in the 10th Circuit case, Franklin versus United States, that the basic framework of sovereign immunity has been waived under the Federal Tort Claims Act, and that these subsequent acts, including the Gonzalez Act, are buttress that point or bring those claims within the Federal Tort Claims Act.
Counsel, you seem to be giving a lot of weight to the words "for the purposes of this section." Do the words "it shall not apply" not matter to you at all?
Again, I think in our briefing we've indicated that what that provision of the statute directs a plaintiff after they've brought their claim at the agency level and failed, that what you do is a claim arising under the Gonzalez Act, medical
But why make it
malpractice.
agency specific?
Pardon?
Why make it agency specific? Why include just a few agencies, whereas in few other acts, Congress?
In this case, black letter tort law holds that most of the time someone who commits an intentional tort cannot be acting in the course of their employment. Consider an example where you go to the Social Security office, you apply for benefits, the clerk loses her temper and punches you in the face. That would be an intentional tort, but she's not doing that in the service of the Social Security
So we are
Administration.
calling in the scope of employment and acting within the scope of employment, right?
What I think what the Gonzalez Act is getting at is that there are certain instances where it's possible to commit an intentional tort within the scope of your employment. An example of committing an intentional tort in the scope of your employment would be if you were a bouncer at a bar, and in the process of removing someone from your bar, you roughed them up more than you should have, or you battered them or punched them in the face, something like that. What we've recognized in these cases of medical malpractice is that someone could also lay out a claim for what's called medical battery, or just I didn't consent to the surgery, whether it's certain.
Counsel, you seem to be reading very far into the intent of the Gonzalez Act. The first clause says, the intent of the act is to protect military medical personnel from malpractice liability. Considering King stating that it has to be an unequivocal statement of liability wavering, where do you draw that as the intention of the Gonzalez Act?
The Gonzalez Act is consistent with this notion that when we apply, I guess I would concede that within the text, it's not explicit within the text of the Gonzalez Act. We concede that. But the point that what we would ask this court to do is consider the fact that the Gonzalez Act was passed to mesh with the Federal Tort Claims Act, and the Federal Tort Claims Act includes a blanket waiver of sovereign immunity, and that's also pointed out in some of the case law as well.
Counsel, in a past ruling, this court took a very similar phrase from the Westfall Act and interpreted it more the way that respondent is arguing we should. That was a point respondent brought up in their brief. Now, how would you reconcile our ruling in the Westfall Act with this act, and how you're asking us to rule?
Could you give me some more to work with on that question?
The Westfall Act had, I don't have it in front of me, but it had a similar phrase, very, very almost identical to the phrase in question in this act.
The court held that the Westfall Act bars recovery against a government employee even where the FTCA itself does not provide a means of recovery. Smith immunizes government employees from suit even when an FTCA exception precludes recovery against the government.
So I guess is your argument that we need to, because you seem to be trying to say that redress is necessary in cases where somebody is injured, they need to be able to find redress and through somebody. And
I apologize if I cut you off. We're not going that far. It's within the province of the legislature to determine what claims can be made and what claims are available. If the legislature wants to totally abrogate a class of claims, they can. That's their power as the legislature. We find it interesting that at no point have they departed from this. I guess what we're trying to say is, if they wanted to get rid of an entire class of medical battery claims, it would have been much easier to do that in a way other than what the respondents have pointed to here. And we think that within the framework
Counsel,
of
what would be an easier way for the government to do that? What kind of language would make it unequivocally undeniable in any instance that the government would or would not deny claims here or there?
You could one of the criticisms that that opposing counsel might make, it's a lot of people would tend to criticize a medical battery claim on grounds that it could be frivolous or easy to fabricate or something like that. But if you look, through the entire history of the Gonzales Act.
If Congress really wanted individuals or intended individuals to sue against the government, why would they even bother to distinguish between an intentional tort and a medical battery?
Again, the theory with the intentional tort is that most of the time if an employee of the United States commits an intentional tort, he's not doing that in the course of employment. It's different with surgery because a Navy surgeon in this case can still be operating within the course of his employment by doing the surgery while also committing an intentional tort by performing the operation without consent. Again, what we're trying to get at is, I think this court, I would ask this court to just consider what the Federal Tort Claims Act was set up to do, and then consider whether the Gonzales Act was really set up to start chipping away at the waiver of sovereign immunity.
Counselor, throughout your briefs, you mentioned a lot of congressional testimony, in particular Senate hearings, as well as a statement from the Attorney General to support your arguments in favor of this waiver of sovereign immunity. At what point do you expect the court to allow congressional testimony to influence the interpretation in this case?
If I would direct this court, I think this court in Dolan versus the United States Postal Service, at that time, this court did look at congressional intent and decide that when the court is looking at exceptions to the waiver of sovereign immunity, such as under 2680(h), that all those waivers should be considered in light of the purposes of the Federal Tort Claims Act. By way of analogy, we're arguing that the same standard ought to apply here. That the general rule now under the Federal Tort Claims Act is that if somebody has a valid claim against a federal employee, they're going to proceed against the government. There's an exclusive remedy provision in section 2679 that says, that this type of claim can only proceed against the government. That provision was added again to give individual employees further immunity protection by preventing somebody from bringing another action in state court if for some reason their federal claim failed.
On the issue of filing in state court, on page 37 of your brief, you detail a lot of jurisdictional issues that could arise based on state-to-state interpretation of what medical battery actually constitutes. What is the likelihood of one of these cases actually coming to fruition?
Well, as I understand it, and as was articulated in our briefing, medical battery can either be pled as a negligence action or an intentional tort, depending on the facts in that case. Again, it differs from state to state. If you were in one state, you might argue, well, my client withdrew consent and you were negligent because you didn't perceive his.
So are you arguing for a case-specific analysis of sovereign immunity? So is this going to be based, every case comes to the court and we're going to have to hear about the different facts in the case and decide on sovereign immunity? Or is this just your view on the reading of 1089E?
I don't know exactly how to answer that question. I would admit, but I just think what this act is trying to do is trying to further personal immunity for individual employees while still allowing that intentional tort claim against a Navy surgeon in this case to proceed against the government. That's been the frame. This is consistent with that development in the statutes.
I understand that. I understand that you're talking about, that's why I see two questions at play here. One is regarding your reading and the meaning of 1089E, right? Which you're claiming is right and different from that of the government. And we have another question at play here, which is if the immunity of the government and the ability of individuals to sue against the doctors. Do you even have to go that far to assert that your reading of 1089E is correct? Or would you go that far?
I mean, I don't know if this is responsive to the court's question, but I think again, our reading of the statute is under 1089, if you've got a claim arising from negligent or wrongful act of your position, proceed under the Federal Tort Claims Act, and the only proviso, or the relevant proviso here, is proceed under the Federal Tort Claims Act, but when you do, pretend that 2680 doesn't exist.
Counselor, suppose that we were not to recognize that there's an implied waiver of sovereign immunity in this case. Would your client have any other legal avenue in which to seek reparations for damages?
Again, to your point, we're arguing that by directing someone under 1089 to proceed under the Federal Tort Claims Act, that's an implied waiver because it's waived in the Federal Tort Claims Act.
But if we were to go with the respondent's suggestion that sovereign immunity can't be waived by an inference, that it must be expressed unequivocally, if we recognize that, would your client have any other legal avenue to seek reparations?
In this case, because of Section 2679, the exclusiveness of revenue provision, and the way that that's invoked, I don't see how. The exclusiveness of remedy provision would prevent my client from suing in a local court in Guam. Our negligence action was deficient because my client didn't get the expert testimony that he needed. So I guess to answer your question, I don't see how he would have any claim left. And this is somebody with severe eye damage.
Similarly, you raised these same concerns of no other avenue of redress, specifically in the states of Pennsylvania and Tennessee, due to their state, limitations on what constitutes medical battery. Can you expand upon this issue a little more?
Well, again, I'm not gonna pretend that the legislature doesn't have the power to abrogate a class of claims. That's what they do. They make laws. But I think in this case, I just think it's important to be careful that we're not abrogating it, hurriedly.
Your client, however, did have the ability to file suit and failed to follow the procedures of the court, correct?
Yes, I admit that the negligent, a showing of medical negligence requires expert testimony, and I believe it when my client was still a pro se, was still proceeding pro se, that he failed to obtain an expert witness. But I think the other thing to remember is not every bad thing that happens in an operating room is going to sound in a medical negligence action. Like the case we have here. This is, maybe it's an oddball case, I'm not sure, but I think consenting to surgery is important. You shouldn't have an operation that you don't want. And again, and in my case, we're dealing with someone who fought for his country. And I think it's
Counsel, your opinions on your client's side, what language should congressional bodies look to again, unequivocally waive sovereign immunity, to avoid these kind of questions of inferences before? What do we look at as a standard or a bright line as justices in trying to interpret these kind of statutes specifically? We've really failed to hear this.
I guess by way of maybe arguing the opposite point, what we think is unworkable is to say, okay, well, we've got the Federal Tort Claims Act that has a broad waiver of sovereign immunity. So when a subsequent act is passed that, again, meshes with the Federal Tort Claims Act, I guess the system that we think is unworkable is, okay, well, if they've already made it, I guess again, we're making an implied waiver argument. If your act is dovetailing you or is directing you to proceed under an act that waives it, we just think it's natural. So
should Congress be expected in every statutory piece of legislation they enact at this point forward to say that this is not an inferred, waiver of consent?
Well, I think that an overly strict approach to waiver of sovereign immunity, I just think that approach is looking for too much. I think if Congress says...
Counselor, this court in the past has ruled that the waiver of sovereign immunity must be unequivocally expressed. I'm just wondering if you can explicate a little bit more your position as to why the court has a duty to explicate an implied waiver when the text does not exist.
This court noted in the Dolan case that the Federal Tort Claims Act is different, given the broad waiver of sovereign immunity in that case. Again, we just think that it's the next logical step in that argument is if another act tells you as a plaintiff to proceed under that act, that those exceptions to sovereign immunity should be viewed in light of the policies of the Federal Tort Claims Act. We just think that, we would submit to this court that...
Wouldn't judicial review in cases like that then start to become legislating? Wouldn't we be making law by drawing implications from the legislator's text?
I guess I don't see how necessarily why the court would have to make
Counselor, if Congress had intended to provide a remedy under the Federal Tort Claims Act for medical battery specifically, why didn't they just amend Section 2680H itself, as it did in 1974 when it enacted the law enforcement proviso?
Could you repeat the question?
Yeah, so if Congress had intended to provide a remedy under the Federal Tort Claims Act for medical battery itself, why didn't they just amend Section 2680H of the Federal Tort Claims Act for medical battery?
In this period of legislation, again, if you look at the Veterans Affairs Act that was that the 10th Circuit handled in Franklin versus the United States, the approach to legislation at that time was to deal with with individuals on a case-by-case basis. So, there's more than one way to skin a cat, and in this case, the legislature decided to amend and augment the terms of the Federal Tort Claims Act on a class-by-class basis, and I don't necessarily think that's any wiser or wiser or foolish than making a direct amendment to the Federal Tort Claims Act itself. Again, I just think that when we're dealing in this area, that this court's guidance in Dolan means something. That if we're gonna have this system where federal employees are immune from suit, while also continuing to provide redress for plaintiffs, that we need to think about these exceptions in light of the purposes of the act itself.
Okay, how do you respond to respondents' claim that Congress has the ability to speak more clearly if they intended to waive sovereign immunity? They quote in their brief the VA Act that you just talked about, which omits the introductory clause and states, quote, "The exception provided in Section 2680H of Title 28 shall not apply to any claim arising out of a negligent or wrongful act or omission by VA or medical personnel."
I'm going to need you to repeat that question.
Okay, so how do you respond to respondents' claim is that Congress has the ability to speak more clearly if they intend to waive sovereign immunity. And they provide an example where they do that in another case, which is the VA medical personnel case that you just brought up in your answer. And in that, they quote it, and they say, "The exception provided in Section 2680H of Title 28 shall not apply to any claim arising out of a negligent or wrongful act or omission by VA or medical personnel."
I think I don't know if this is the answer that the court's looking for, but we would just submit that. This is the system that's been in place for decades, where there's a broad waiver of sovereign immunity in personal injury torts, and this statute builds on that. It's trying to get as many claims into federal court on this basis, keep claims from state court, reduce personal immunity. But at bottom, I guess what we're arguing is we've started this act started us down this road, and these subsequent acts have only reinforced it. We haven't undercut the general waiver of sovereign immunity. And
Counsel? So how would you respond to respondent's argument that Congress in fact intended to differentiate between battery claims and negligence claims based on the premise that the former is difficult to defend? He talks about the clever plaintiff argument, and this is essentially, I understand, a policy argument, but how do you respond to that?
We would respond to it in a couple ways. Again, in Dolan versus the United States Postal Service, the argument against the claim was that it's a slip and fall claim. And slip and fall claims are maybe unfairly notorious or unfairly characterized as being ridiculous or frivolous or hard to prove. But that's not what this act was set out to do. If they wanted to, if the government's big problem with these claims was that they were hard to prove or that they allowed for a clever plaintiff, then just get rid of them. Like, that would be the most natural way to get to make sure that these aren't brought up. But this doesn't do that. So
Counsel, I want to draw your attention to your writ of certiorari. Your client's claiming an interest in the due process clause. How is that applicable to the circumstances of this case?
Gosh, I didn't even see that.
You're familiar with due process, then?
Yeah.
How would you apply it to the circumstances of this case?
You're gonna have to help me out. I don't even remember if it was a procedural due process or a substantive due process argument.
Touche.
I believe that you're claiming that if we take the respondent's perspective on not accepting an implied waiver of sovereign immunity, that we've immunized government employees from intentional tort claims in this case, but we've also closed the legal avenue of suing against the government that Gonzalez seems to imply. So yes, so your client would thereby have no legal avenue to pursue reparations.
And I guess that again, I apologize for not being up on this, but I think the argument that you would make there is that if by making it so that this class of plaintiffs has absolutely no avenue at all, you're denying them, a due process right to either the access to the court system or the right to have access to the court system. And
in this case specifically, however, your client initially had access to the court system and failed to provide the burden of proof by getting expert testimony.
But that's with respect to a negligence claim. We also have that's pled differently. That's a different cause of action again.
Why then did your client feel the need to file suit under both for two charges?
Well, if two things happen, you can. If there's either two things that happen, you're entitled as a plaintiff to plead as many plausible theories of recovery that you have. I see that I'm starting to run into my rebuttal time. If the court has a final question, okay, I'll reserve it to you.
Thank you, Counselor. Counselor, are you ready?
Chief Justice Roberts, Justices of the Supreme Court, Counsel, ladies and gentlemen, my name is Joseph Meyer. I'm here on behalf of the United States. We are the respondent in this case, and of course what we're here to do today is convince this court that the Ninth Circuit decision in Levin should be affirmed. And what I want to talk to you about is three issues that I want to address. These were addressed in our brief, but I want to bring them up again this afternoon. First, our point is the Gonzalez Act does not unequivocally waive sovereign immunity. And because of that, and the long line of cases that this court has recognized and issued, there cannot be the waiver that's advanced by the petitioner in this case.
Counsel, how do you reconcile Petitioner's argument that Dolan versus the United States Postal Service means that in some cases an unequivocal waiver is not necessary, as the court has ruled in the past?
Well, Dolan, as my understanding of the Dolan line of cases was that you were looking directly at a statute, and that's our first point in our brief against Dolan, that it shouldn't apply in this case. Dolan suggested you got to look to the statute as a whole and look into that statute and see how the various statutory provisions apply. Dolan is misplaced in this situation where you have a statute that's enacted, such as Gonzalez, the Tort Claims Act was enacted.
Counsel, if you take that position, then we're just keeping on extending ourselves, aren't we? Because there's an exception under the Federal Tort Claims Act and another under Gonzalez Act. So you're talking about an exception of an exception, and how far are you willing to go?
With respect, Your Honor, I don't believe that's true. There is certainly an exception built into the Federal Tort Claims Act, but Gonzalez does not contain an exception to the U.S. government sovereign immunity.
Counselor, during the 1980s, the United States, in a brief regarding this similar issue, stated that the Gonzalez Act, in fact, did provide for a waiver for these types of suits, and it's noted in Petitioner's brief. Coupled with legislative intent that Petitioner acknowledges, was there not intent to provide for this waiver?
We don't deny that this was contained in a brief before that was submitted, and I would suggest that that is not binding precedent in this court. It's not binding on the United States. It was argument at that point in time. I recognize that Petitioner has raised that, but we don't believe that goes to the issue, which is there an explicit waiver? This court has said it has to be explicit.
This court has also noted, though, that quote-unquote magic words are not required to waive immunity.
I agree. It says that magic words are not necessary, but a petitioner cannot show this court where those words are.
So are you asking for literal text saying we waive sovereign immunity? Would that provide for a reasonable standard in your view?
I guess what I'm suggesting, and it was suggested in our brief, that when Congress wants to explicitly waive it, we don't need to have magic words, but we do need to have some explicit language. And this court has long instructed in cases such as Lamy and in cases that are cited in our brief that it's not the court's province to engraft legislative intent if the language is clear and unambiguous, and we believe that the language is clear and unambiguous in this case.
In regards to Section 1089D, then, where it specifically empowers power to the Attorney General to deal and to settle suits against individual employees, would this not lend itself to the plausible interpretation that Petitioner has noted?
As indicated in our brief, we do not believe that's a fair reading of subsection D of that section. We believe that's the remand that allows the government to step in. It does not create the waiver of immunity that this court has long instructed must be clear and unequivocal.
Counsel, if we accept your reading and the government medical employee in this case is immunized from liability for intentional tort claims, and the government maintains sovereign immunity, by what legal avenue is the petitioner supposed to seek reparations in this case?
Justice Ginsburg, to answer your question, first I must say that the petitioner and the respondent are not in disagreement that the Gonzalez Act specifically denies a remedy to the individual. Secondly, I think this court has recognized in cases such as in Rees-Smith that there are situations where the person may be denied a remedy, but that should not allow this court to
So
go
in this
beyond
case, if there is no
Congress's
remedy, what is there to keep the government from keeping this from happening again? I guess what is there to persuade doctors not to ignore an oral retraction of consent to use experimental surgeries or to, in this case, damage the plaintiff's eyes?
I think this court recognized when it issued its decision in Smith that sometimes you have harsh results. I also think that you can't ignore the facts in this case, and that's specifically that petitioner had a cause of action with respect to the negligence and failed to carry their burden in that, and the government quite easily got out on summary judgment because they did not advance.
So, counsel, under your view, is there no remedy to battery claims at all?
Pardon me, Your Honor.
Under your view, is there no remedy to medical battery claims at all, or is there?
Well, I think the reading, our reading of it is that the Gonzalez Act, Congress advanced the proposition that, first of all, we would immunize medical doctors, dentists, etc. From negligence and medical battery claims. We would give the remedy to the plaintiffs in the Federal Tort Claims Act, and then I think you have to read the Federal Tort Claims Act.
Counselor, while I agree with you that we must be extremely careful not to overstep our judicial authority and to legislate, If no legal remedy is provided by the laws established by the legislature, wouldn't that be in clear violation of the 14th Amendment?
Well, Your Honor, I guess my response to that, and again, I'm repeating myself, is that this court's decision in Smith specifically recognized that
Regarding
issue.
Smith specifically, since you're uncomfortable applying Dolan in this case due to different circumstances, Smith clearly had different conditions, legislative history, and FTCA exceptions listed in Smith. Why then are you able to apply Smith in this case, whereas Petitioner is unable to apply Dolan?
Because I think unlike the facts in Smith, we do not have a situation where you have an ambiguous statute. I believe the language of this Gonzalez statute is quite clear, and while the Ninth Circuit clearly recognized that notwithstanding language in subsection E creates an initial plausible reading, the Ninth Circuit then went on, and we believe correctly went on to say that what Congress was attempting to do in that was to immunize employees of the federal government from these types of suits and to provide the remedy in the Federal Tort Claims Act.
I'm still uncomfortable, however, with your application of Smith and your heavy reliance on Smith. Can you provide further justification as to why I should allow our decision in Smith to influence my decision in this case?
Well, I think the point in Smith is to address the argument of the petitioner. And the argument of the petitioner is if this court adopts the argument of the government here, that will not provide a remedy for the individual plaintiff against anyone for the medical battery. And my point is that Smith clearly said, we recognize that harsh result may occur in cases, but it's not the duty of this court to impose its will on what Congress decided.
But in lieu of congressional testimony where it was stated in committee on the floor, as well as by the Attorney General, that there could in fact be exceptions read under the Gonzalez Act, is it not therefore fair for the court to read the same possible interpretation?
We don't believe it is fair. We don't believe it's even necessary for this court to look at legislative history, not only because this court has long since articulated that is not what it should do, but also we don't believe this is unambiguous. We believe that you don't even need to get into legislative history, and despite the snippets that are contained in the plaintiff's brief of the various arguments or history that was before the legislature, we don't believe that supports the petitioner's argument here
Counsel,
either.
in Smith, the executive actually stated 3 times that the statute in question replaced responsibility of medical personnel with responsibility of the federal government. I don't see how legislative history is not relevant here if the executive was able to interpret the statute that way.
Your Honor, are you referring to the brief that was filed by the United States in support of its position in the Smith case?
I'm referring to an argument that was in the petitioner's brief.
In answering your question, what I believe that is, and I think I addressed it before, but I'll go back to it. The argument there was that the U.S. government, in responding to the arguments in Smith, suggested in its briefing at that time that the Gonzalez Act waived for medical battery the Tort Claims Act. And for the reasons stated in our brief, and again here today, we don't believe that is binding precedent, what a former administration said.
Does that lend to credibility of argument, however, for petitioner?
We don't believe it lends to the credibility of the argument at all, because it's not binding precedent. It's argument, no more.
Counsel, in my understanding, the FTCA does allow people to bring suit against the government for negligence claims, but it would seem then that people can sue the government for unintentional harm when it's a negligence charge, but not for intentional harm when it's a battery charge. And I would believe that Congress would try to have some logic in its statutes. I don't see the logic behind being able to sue someone for unintentional harm, but not intentional harm.
Your Honor, I would agree that is a fair reading of the 2 acts together. Gonzalez, we don't believe there's any dispute between the plaintiff or between the petitioner and the respondent that it protects individual medical providers from not only intentional torts but also non-intentional negligence torts. But then when you get to the Federal Tort Claims Act, it does lend to the reading that you cannot sue the government for battery, which is of course what we have here. And I think this court, as well as some of the other commentators, have helped us with that. And it came up during the argument that Petitioner was making. This court has long since recognized that it's very easy to allege a battery claim, but quite another thing to defend against it.
Counsel,
and that
if
was one of
it's-
the things that Congress was concerned about in 1946 when it specifically exacted
Counsel,
that.
if battery is hard to defend, does that remove responsibility from the government? Just because something's difficult to disprove, something that they might have to spend money on or go to court for, does that remove responsibility?
I don't think I'm saying, I don't think I'm advancing the argument that it removes the responsibility of the government of that. I think I'm just simply stating that the long history of this court interpreting the Federal Tort Claims Act has specifically raised that issue as one of the reasons Congress was so explicit when it passed the Federal Tort Claims Act to immunize it, or better said, not to release sovereign immunity with respect to medical battery or battery issues, intentional torts.
Back to the issue, I'm still not satisfied regarding the magic word doctrine or the unequivocal waiver. At the point where we clearly have established there is a plausible reading, at the point where we have legislative history, we have the testimony of former agents of the state and former attorney generals of the state, what line are you expecting the court to follow in this case specifically, where there is in fact a plausible reading, if not a probable reading of a waiver of immunity?
I guess I'm asking this court to apply its previous rulings, and I don't think we have to disprove the negative. In other words, I think there's got to be clear and unambiguous language in the statute that the government intended to waive the very important right of sovereign immunity. It did not.
But is this not going to advance, like incentivize the government to make more language more ambiguous? And like I was saying in the beginning, I don't know if you ever got back to me about the exception. There's an exception in the first act, and there's an exception in the second act, right? And how many are you going to extend? How far are we going to go if we rule in your favor?
Your Honor, I think what I'm focused on is this court's precedent that says it must be unequivocal waiver. There must be a showing of a waiver. This court has long held that it can't find Congress's intent from a plausible reading. It must be unequivocal of this important right, which is the waiver of sovereign immunity. We're not asking you to do anything other than to read the statute and to find that there is no waiver. If Congress had intended to waive it, the language does not say that.
Counselor, clearly, seeing as how the court certified this question, there is at least 4 of us that believe that there is a high probability of this waiver being in the text of the Gonzales Act, although it is not unequivocal, as you say. Do you care to elaborate any further to try to win over those?
Well, I think you start with where the Ninth Circuit started in when it was looking at the Gonzales Act. The Ninth Circuit started with the statement, and I'm paraphrasing now, but it started with the statement that said, at first blush, you can argue that language that's in section 1089E, which says specifically, for the purpose of this section, notwithstanding, that language, when you first look at that, would indicate that maybe there was some intention on behalf of Congress to waive sovereign immunity. But as we pointed out in our brief, if Congress wanted to do that, it could have done it like it did with respect to the VA Act that's in our brief. That's section 38 U.S.C. 7316F. Specifically there, Congress knows how to draft language.
So specifically in section 1089D, again, where the Attorney General is explicitly guaranteed the power to settle individual cases against individual doctors, could this not be read by the court, therefore, to be that exception that you're asking for?
And I don't believe that D gets the petitioner where the petitioner wants to go. D suggests that the government is given the right to settle claims, but that doesn't go to this clear federal issue, which is sovereign immunity waived by the language of the statute.
Counsel, I'd like to return to Justice Breyer's question, because if she's satisfied with the answer, I am not. I'm curious, if we were to accept the reading that Gonzalez, obviously it has the one intent of immunizing government medical employees from intentional tort suits, but if it doesn't have the second intent to infer a waiver of sovereign immunity, it would seem that it renders subsection E of the Federal Tort Claims Act inapplicable to subsection H, and that we can no longer seek reparations through a suit against the employee. And if we are not allowing them to seek reparations through that avenue, and we have not waived sovereign immunity for them to seek reparations against the government, how is this not a clear violation of the due process clause, in which case this is a clear suit in which somebody is alleging the government has damaged their person, and therefore to no way of receiving anything from it?
Well, Your Honor, there's a lot of meat in that question. Let me see if I can answer as much of that as I can. First of all, with respect to the due process question, sovereign immunity can be or not waived by the sovereign, and this court has long since recognized that. And so the fact of the argument that's being made by the petitioner that we've lost a remedy against the sovereign, I don't think that falls into the due process protections that this court normally worries about. The second issue is, can Congress, as it did here in the Gonzalez Act, step in and say, not only are we going to protect the government by not waiving sovereign immunity, but we're going to protect the government's employees by specifically saying you won't have a negligence cause of action against those government employees.
So you consider within the due process clause that the government can immunize its medical, military, and personnel employees and allow them, in this case, to potentially damage the petitioner's eyes after he withdrew consent, and that it's within that they're not afforded any repercussion against the government?
I'm not saying that. I think this court said that in the Smith case in 1991.
Counselor, I'd like to clarify your position in your use of the Smith case now. So, while the Gonzalez Act immunizes medical personnel from tort suits, and the FTCA immunizes the government from tort suits, this means that legal remedy no longer exists for petitioners in cases of battery, correct?
That's our argument.
And you're reading Smith to say that this is an unfortunate consequence of federal tort law.
That's our argument.
Okay, thank you.
Justice Ginsburg, I'm not sure I was done answering your question, but
If
there
you'd
are
like
many
to
questions.
continue, you may.
I guess I'm just simply back to the point of that. Yes, sometimes we have harsh results, but that overlies the very important public policy that the sovereign can waive immunity, but it must be explicit, and we don't have that here. Further, my points were that the precedent would suggest that Congress hasn't gone as far as petitioner would like it to go. It's had several opportunities to waive immunity for torts, and it hasn't done so. And in our brief, we've cited 3 different examples of that, where they've used identical language that they used with this case, and then it wasn't until 1988 with respect to the VA medical personnel that it specifically used language that clearly expressed the type of language that this court has long recognized must be there. And it's not magic language, but rather an explicit understanding that government intended to waive the sovereign immunity. Your Honor, just a couple other points before we get too much further off the beaten track here. No, I've lost. And I'm somewhat repeating myself here, but 10,000 1089E, we would suggest does not amend the Federal Tort Claims Act. If Congress had intended to do that, it could have done that. It's done it before. It did it I believe, in the 1970s when it amended the statute. It did not amend the Federal Tort Claims Act here. It simply enacted Gonzalez, which we believe, of course, goes to the individual.
Why then use ambiguous language? Why not say it straight? Like, the petitioner seems to be reading it that it has a dualistic purpose, whereas you're arguing it's an absolute purpose. So why not? Why shouldn't have Congress used strict text, which would?
We would suggest that's what they should have done. If they were, as petitioners advanced, they were attempting to waive sovereign immunity. They didn't. They simply used their notwithstanding this section. They didn't talk about a waiver of the Federal Tort Claims Act. They were talking about this section, the Gonzalez Act, the immunization of persons, not the U.S. government. That's a big distinction.
Counselor, do you think the deprivation of legal remedy, as we discussed it in Smith, being an unfortunate result, was the intended consequence of this legislation when it was passed through Congress?
Your Honor, I'm not sure I'm prepared to delve into the intent of the legislature because I haven't had to. And this court has long since instructed that courts, counsel, and judges should not go into determining what was the intent of Congress when the language of the statute is clear. Justice Scalia has been very
clearly others of us have allowed for legislative intent and legislative history to influence and shape our opinions. And again, based on that, what if we cannot use legislative history and legislative intent and legislative congressional testimony to determine what Congress meant by an act, short of these quote-unquote magic words that we're all trying to avoid, what would count as a waiver of sovereign immunity in the eyes of the government?
The government has shown us in two instances where I can think of where there has been a waiver. First, it was in, as I've already stated, the act that's found at 38 U.S.C. 7316F, where they specifically waived sovereign immunity with respect to VA medical personnel. The second place is in the Federal Tort Claims Act itself. That contains clear and unambiguous language. I don't believe we get there by looking at Gonzalez.
Counsel, if the language in this case was clear and unambiguous, I don't think we'd be here today. And considering that Petitioner is not the first person to take this plausible explanation from the language of this statute, then why would the government not have made themselves a little less ambiguous? Why would they not have stated clearly that they did not intend to waive sovereign immunity?
Your Honor, I don't believe it's up to the government to clearly state we're not waiving it. I think it's up to the petitioner to show that they did explicitly waive it.
But considering that Petitioner and people in past cases have interpreted it to mean this, it's such a plausible conclusion to draw. It seems they wouldn't have left it quite that ambiguous.
Well, I guess I'd answer your question that we don't believe the Ninth Circuit took very long to get to that point. We believe it's an argument, not a very plausible one. And so, and to that point, Your Honor,
Since we're talking about the Ninth Circuit, how do you respond to petitioner's claim that there's a counterfactual assumption at play here?
I'm not sure I understand the context.
So basically, petitioner argues that under your view, there is no remedy to medical battery claims at all, because the Ninth Circuit seemed to think there might be some possibility for it. Therefore, he argues that there's a counterfactual assumption at play here, like there's no remedy to medical battery claims at all. So how do you respond to that?
Well, I'm not sure I saw that quite explicitly in the Ninth Circuit decision in Levin. I think the Ninth Circuit was just simply looking at the issue of was there a waiver of sovereign immunity, and they found none. Was it a plausible reading? They found that at first blush it was an argument, but they quickly dismissed that and said that you can't infer waiver from the language of the Gonzalez Act.
However, the government in the 1980s, again, while it may not be binding precedent, in the government's own briefs and their own interest, stated that a waiver was in fact inferred from this act.
I can't run from that, Your Honor. It's there. We're not disputing that fact.
Well then, from the 1980s to this point, what has occurred that would allow us to not see that as a probable, if not likely, waiver of sovereign immunity?
I guess what hasn't occurred would be how I would respond to that. What hasn't occurred, if the government meant it, they've had more than 2 decades to fix it, and they haven't. And number 2, that points you again to the 1998 Act, that's the VA Act. Thank you, Your Honor.
Counselor?
I'll just take a minute to just to reiterate a couple points. Justice Alito, I agree with you. I think that the legislative history in this case is it's important to look at, given that we're having such trouble understanding what this act means. And I think the legislative
Counselor, did you say it's stronger than the statute itself?
I'm sorry?
Did you say the legislative history in your finagled attempts at trying to find intent into the statute is stronger than the statute itself?
I think that the legislative history is a useful tool here where we're trying to figure out what this statute means. And at no point, I think the history indicates that what the legislature was trying to do is to give more protection for federal employees without totally undercutting the system that allows plaintiffs to recover when they're injured.
Counsel, speaking of undercutting that system, respondent makes an argument regarding Smith as to it may be an unfortunate result that this path to legal remedy is indeed undercut. Why should the court be persuaded that we shouldn't rely on this precedent that we've set in the past?
I guess the response that we would have is that, again, totally abrogating an entire class of claims does incur harsh results. And I think that before the court is going to impose such harsh results, I think that it's worth considering whether the legislature intended that. I think that's all I really had on rebuttal. I would just, again, pray that this court reverse the decision of the Ninth Circuit.
Thank you, Counselor.
Thank you. Thank you, Joe and Kirk, and our distinguished justices, and thank you, audience, for coming out and